an easy topic for all of us to grasp. And I guess if we did a scale of 1 to 10, with Jane being 10 and somebody not knowing anything about TPPA being 1, I might put myself around about 4.5. I wonder how many of you would put yourself higher. Is there anyone who would think they're under 5? A few of us under 5, eh? And it's been a difficult subject, I think, for people to connect with, because it's not sexy and gorgeous and emotional in the sense like Maui dolphins or, you know, child poverty, where you can actually touch and see something. It seems quite academic. So for someone like myself, I consider myself to be a broad strokes person, a big picture person, which neatly avoids my habit for having to go into real horrible detail, especially when it concerns statistics, percentages and numbers. I've got a condition called dyscalculia. I'm sure there's a whole bunch of us here. We hate numbers, okay? But we can understand principles. And for me, I guess I would, when I was at law school, I started to really understand what the Treaty of Waitangi was about, not because it was taught, but because people like Jane and David Williams explained it to us. And I think that's a good place to start, because if you step back in time and you think back to 1840 when the treaty was signed, there was like only 3 articles, written articles, and 1 oral guarantee. And even though that looked quite straightforward, we're still dealing with the consequences of it 175 years later. And that agreement was hawked around the country. The Crown really wanted us to sign it, and that agreement said something about a desire to keep out corporate interests. And this whole thing now with the TPPA is completely at odds with it. It's being signed in secret. It's about allowing access to corporate interests. It's flouted basic principles of the treaty, which require the Crown to actively and meaningfully engage with Maori. And they have said they are doing that, have done that, and they have not. So when you look at the broad principles involved, Jane can talk about most of the, you know, she's a world expert on this. If she also tells us just to keep focused on what the impact of this agreement is, big time, long term. So when I break it down, and why many of us are concerned enough to actually stick our name on a claim to the tribunal, which is sort of a big deal when you're a musician. You know, you guys involved in iwi stuff have probably done it quite a bit, but for me it was kind of like a big decision. But it's one that those of us involved put our hands up for, because there's been a history of Māori challenging Crown negotiating big so-called trade agreements in our name and locking us out of the process. Many years ago I did a documentary called Guarding the Family Silver, and actually interviewed the Minister of Intellectual Property, who said that she was never invited to the negotiating table when the Minister of Trade was kind of doing the deals. So even if a minister wants to do something, you know, that's going to be practical and useful for us, they're often locked out of that process. There have been many protests by Māori against previous agreements like MAI and all those other acronyms that I can't remember now, but they all suck. And it's continual. And of course the Y262 claim is one that was where the report was presented in about 2013, and nothing has moved on it. I gave evidence there, that case, because IP was part of that claim, intellectual property, and for those of you who don't know about Y262, it's a landmark case. My evidence evolved around releasing an album in Germany and having a lawsuit sort of moved against me because I released it under my name, which was trademarked by a company. So the question that I asked was, how is it possible that a foreign company can control the use of an Indigenous word or term like my name? So in discussing with Maui Solomon and Moana Jackson and our wonderful lawyers who have been exploring this area, the short answer was the intellectual property system does not have any relationship to our traditional systems of kaitiakitanga. It does not protect our taonga. So the Y262 claim is a huge claim, but it's been sitting there since 2013. The government hasn't done anything about it, and this is why TPPA potentially has a big impact on Māori. So for me, secrecy, we've been locked out of secrecy is one of the main bugbears, in the sense that I don't feel that I need to know everything about the 30 chapters and all their clauses of the TPPA. I don't want to know. What I want to know is that people with the ability and the skills and the expertise and the knowledge to deal with that will be able to assess the risk on my behalf. Okay? So that means public health professionals, that means intellectuals, academics, environmentalists, that even means our opposition parties, everybody being able to look at it in the best interests of Māori and the public. We haven't had that opportunity. As Māori, we have been locked out of the process, and the Waitangi Tribunal claim made that quite clear. They had grave concerns about the lack of real engagement. The Crown said they had engaged, they had consulted, but, well, that was a bit of a joke really, because first they sort of name-dropped Ngāti Kahungunu, did a bit of a haka and said, well, hello, I don't think so. And then they sort of mentioned that there was one woman who asked a question at a hui up north, an unidentified woman from a unidentified group, and there was no documentation supporting it. So therein lies the consultation process, what evidence we could find. The tribunal said that the Crown has treated Māori as domestic stakeholders, not as a treaty partner, and that had grave concerns about that. What we are concerned about too is just saying something about the secrecy, which is quite hilarious, really. I mean, you have to have a bit of a sense of humour in this whole thing because it's so stupid. Is that the government said they consulted with Māori, and then the tribunal said, well, it would be really good if we could see the text. The tribunal. It's quite a flash bunch of people on tribunal. And the Crown said, well, no, we can't show you that because it's secret and confidential. And so the Crown said, well, could we... Now, what was it? What did they say there, Jane? Hang on, I've got this because it's so silly I had to write it down. The lack of process. Oh, yeah. Okay, here we go. Tribunal asked to see the text of the TPPA, especially the Treaty of Waitangi Exception Clause, that the Crown says protects Māori rights under the TPPA. The Crown refused on account of the TPPA being secret. The tribunal said they'd keep any documents confidential. The Crown refused on the basis that it's all too complex. So you're all a bit not the brightest on the panel, was what they were saying. So I'll be thinking that the Crown is shooting itself in the foot here, because you can't say, well, we've consulted and everything's confidential. So the tribunal gave it another shot. They issued a formal direction that the Crown and Claimant Council work together to appoint an independent expert with experience in international trade and investment law, as well as a sound knowledge of Treaty of Waitangi issues. The suggested person was quite a flash QC, and that QC would advise the Crown on whether the Treaty of Waitangi Exception Clause was adequate. Our lawyers worked up a proposal and sent it to the Crown lawyers, but that was a no from them. They said that basically we'd muck up the whole process. They can't change anything. It'll just be too much of a drama. So, you know, this is the process. This is a tikanga that the Crown has adopted. It's a very, we've used the word contemptuous tikanga for Māori, and it sets a precedent for what might happen in the future in terms of other agreements of a similar nature and impact, that this is how we're going to be dealt with. This is how all New Zealanders are going to be dealt with. This is how Maori are going to be dealt with, not dealt with at all. So I'd just like to acknowledge Prua Māori Women's Welfare League for putting a stake in the ground there. The Whaios of the Mutu have made their stance very clear. And more and more people are actually clicking onto this thing, this TPPA, that it has got far-reaching consequences for us. It's very nerve-wracking. It has a potential to impact upon Māori in the future, Māori who are undergoing treaty claims against the Crown for breaches. And Jane will talk about that in more depth, but it is a big, potentially life-changing and society-changing kind of a document. It's huge. And that's why we all need to put our hands up on this one. So I am thrilled that everyone's come along here tonight so that we can all learn together about this document, this agreement. And you know, I suppose to sum up at the end, I think, you know, you can get a little bit depressed about this and think, oh my God, it's bigger than a bread box. It is, it's huge. But you know, one thing that I find uplifting is we're not alone. There's heaps of people around the world that are marching. There's like 200,000 people marched in Berlin like a couple of weeks ago. Because guess what? They've got another ugly document over there that's the same as ours. It's like the ugly stepbrother of the TPPA. And then there's this other one. There's 3 of them. And guess who's all in the middle? Oh my God, USA, right in the middle. And so there's lots of people around the world, ordinary people, that are marching, that are making a stand, and then there's pretty high-powered people like Senator Hillary Clinton and Elizabeth Warren, and economists, Nobel Prize-winning economists, people from the WHO, the World Health Organization, heavyweights, heavy intellectual weights. Not all raving Marxist nutters like Jane Kelsey. Shut up. So, you know, we're not alone, people, and that's what we can take heart from. So, kia ora koutou.
Kia ora koutou. E kuima, e koroma, he mihi nui kia koutou. Ki ngā tangata whenua o tēnei wā, o Tākapārawha, me Ngāti Whātua katoa tēnā koutou, e ngā iwi o ngā hoiwhā tēnā koutou. This is always an emotional place for me. I count it as one of my great achievements in life that when I get questioned at the Australian immigration, when I go through about my criminal convictions, one of them was up here. Not in the first batch, I was in the second batch. So, kia ora to those who struggled for this place. All right, let me start by saying a couple of things more about the process that my mate Moana has talked about. One of the frustrations about the Trans-Pacific Partnership Agreement, which is that for the past 5.5 years when I've been tracking this, we have been told on the one hand that we don't know what we're talking about, and on the other hand we can't see anything so that we can actually point to things and tell you what it's really about. But I want to say that what I'm going to talk about now for a little while is based on the best knowledge that we've been able to gain from tracking, going to the meetings in the lobbies, talking to the negotiators, monitoring the leaked texts, doing everything we possibly can to break through the shroud of secrecy that surrounds these negotiations. And one of the most important questions is, if this is so good for us, why are they so determined to keep it secret until it's too late to do anything about it? Yeah? Now, Ngāti Whātua has negotiated with the Crown for a very long time. And a deal where you're doing a deal and you don't actually get to see what's in it until it's done is a deal that you can't trust. And even if they tell you their version of what's in it, you know that the fine print is always going to carry fishhooks. And you know that even if you think you understand what is in the document, the unanticipated consequences sometime down the track can come back and mean that it's something very different from what you thought you were adopting. And that's why we've always insisted that we have to see what's there before any deal is concluded. Yet, when they started these negotiations in March 2010, the countries negotiating it, and there's now 12 of them, including really big countries like the US and Japan and Canada, they said not only will everything be secret throughout the whole of the negotiations until the deal is done and then we release the text, but all of the background documents that show you how we got there will be secret for 5 years beyond when the agreement actually comes into effect. So you can't hold anyone who made those deals to account for what they did. And I don't know about you, but that in itself makes me highly suspicious. Now, when we've been working on the negotiations, we've had a number of leaked texts. Right? So we've been able to see quite a lot of what has been out there. And those leaked texts gave us massive cause for concern. Right? Now, they're terribly complicated things. As Moana said, there's about 30 chapters in this agreement. Up until a couple of weeks ago, they wouldn't even tell us the names of the chapters. But we got some of the most important of the chapters out. And there were then really big campaigns around them. And I am really pleased to say that giving voice to people's concerns has had an effect. We know that some of the worst things that were on the table are no longer on the table. But we also know that a lot of what is still on the table is still toxic. Now, they announced that they had reached an agreement a couple of weeks ago in a meeting in Atlanta. And a lot of people thought, okay, that's it. We can't do anything more now. It's done. And before I go into why we should really be concerned about the content, I just wanted to reiterate that it is not beyond our control. Right? There is still at least 3 months, at least 90 days before they even sign the deal. Right? And then there will be a couple more years before it is a done deal in the way that it binds Aotearoa New Zealand. Right? So we've got a couple of years of fighting this. Now, it was always going to be much easier to stop it before the deal was done, before they did the political trade-offs. But it doesn't mean that we can't still make a difference. Right? Now, for Maori, as Moana said, the process of the secrecy has been even more insulting. Tino rangatiratanga doesn't just mean a stakeholder, doesn't just mean a partnership, it means a constitutional relationship. When the state does something, iwi Māori have a right to be right there in the centre of that decision making. When we asked them what role Māori had had in the process, Māori weren't even on the list of stakeholders, let alone treaty partners, let alone constitutional players. There was one Māori entity on the official list of stakeholders, and that was FOMA. Yeah? And then there were a few others who were in there as having been consulted because they'd happened to turn up to some meetings. Now, in the past, back in the late 90s and early 2000s, there had been real pressure brought on, especially about the intellectual property issues, but also about the constitutional issues and around protections of a whole range of Māori interests. And I have to say, TPPA had taken the initiative and got consultation hui around the country, and there were people who turned up at those hui everywhere saying this is not acceptable, and they had a voice. TPPA was lost in action this time. No one was actually there except for Hone Harawera, Mana Party, and Te Ururoa and the Māori Party. And I have to say that the Māori MPs from Labour have been lost in action as well in the public domain. But there were some people, but there was no platform, because they were locked out. Now that the deal is done, Minister Grosser is saying, oh, we're now going to go and consult, which means we're actually going to tell people what we've done, but our version of what's been done. We're not going to take anything on board because we're going to tell everybody that nothing can be changed. And so that is part of the reason for the Waitangi Tribunal claim. That is to say, this is unacceptable. It needs to be reopened, and there will be a hearing at the end of this month to have an urgency hearing in the tribunal before the end of the year, so that before the deal is signed, the voices can be heard. So I just want to talk a little bit about what the tribunal claim is about so that you can see some of the substance of the concerns. The first essence of the claim is a breach of tino rangatiratanga. So that fundamental constitutional question is at the core of the process. And when the Crown was talking about why it couldn't allow the tribunal or anyone to see anything, but they assured everyone that it was done, and we said, well, why are other countries able to see more than people here? And they said, oh, that's because they've got special processes. And Doug Kidd said, well, we've got a treaty. And the Crown just didn't have an answer. So when you've got a former National Cabinet Minister actually raising the issues, yeah, the tribunal gets it. The tribunal claim itself has 4 substantive questions. Right? And these were 4 things that we know from what's in the public domain will impact significantly on Māori. The first, which Moana's mentioned, is the Y262. The intellectual property chapter, if you think about who is behind this deal, it's not just the governments of those countries, it's the big corporations. And it's the ones who want access to Indigenous knowledge, they want the plants and the seeds and the rongoa, and they want the music and the icons and the, right? Because there's big money in that. And this is where the lie about this being anything to do with a free trade deal comes in. This is about giving monopolies to those companies, giving them exclusive rights for longer periods of time to make money out of that knowledge. And there are many different aspects of it in what Moana was talking about in terms of the copyright and trademarks. There's big issues there, and in fact the copyright will be extended for longer periods of time, 20 more years to lock up that knowledge. But one of the biggest concerns with Y262 was about the natural domain, and the right for consent, the right to exercise kaitiakitanga, the right to be able to get returns if there is something that you are entering into that's an arrangement that you have agreed to, that you have an entitlement to a share. All of that is run roughshod over. And one of the features of the agreement is that it put handcuffs on the future. So all of the unresolved Y262 issues then can't get resolved because the government has signed away the right to do that in the future. And so when the Y262 arguments were put forward, the Crown said, oh, but we've got this Treaty of Waitangi exception and you don't need to worry about it. And we said, well, show us the exception. Oh, no, can't do that. But it's kind of like the ones we've had before. And we said, hold on, but the ones we had before don't provide any protection for intellectual property. Huh? What they say is the Crown reserves the right to give a preference to Maori if the Crown thinks there is a treaty issue and the Crown wants to do something about it. It can give preferences to Maori, but it can still be challenged if it is considered to be arbitrary or unfair discrimination against foreign interests. Now, what we said was, well, but what you've got to do is to say, we're not going to sign up to these international agreements that the US wants us to sign up to because it will mean that we can't implement Y262. That's not discrimination. That's nothing to do with your treaty exception. Yeah? Doesn't solve your problem. They said, oh, no, it's fine. And then we got a leak of the final text in the IP chapter, and that showed us that, in fact, we were right. And they went back at the last minute and said, oh, look, we're in trouble back in Aotearoa. We've got this claim, and so we've got to throw something in the back of this IP chapter. But what they threw in there wasn't a proper protection. Yeah? And so we've had them admitting that the treaty exception doesn't in fact provide the protection, gone through the back door to try to save face when they end up in the tribunal again, and it's still not effective. So on the Y262, we will be having lots of fun. And when I say we, I'm been doing the affidavits for this. Obviously, I'm not one of the claimants. But Moana Jackson, who was one of the key players in Y262, is one of the claimants. The second part of the claim is about health and about medicines. Paparangi Reid is one of the major claimants in terms of that. And we know that Māori are the most dependent on access to affordable medicines to deal with the impacts of a whole range of illnesses, unwellnesses, some of which are derived from colonisation and some of which are derived from poverty. And we know that the agreement was going to increase the price of medicine significantly. It was going to make it much, much harder for the drug buying agency, Pharmac, to be able to, with the pot of money it has, buy what's needed. Now, because there's been a bit kickback by the health sector here and internationally, we know it's not as bad as it was. But if you go to the Herald this morning, you'll see that there's an op-ed in there by Dr. Josh Freeman, who's one of a group called Doctors for Healthy Trade. And they show why it is still going to make medicines much more expensive. And we know who that's going to affect. Yeah? It's either going to mean there's fewer subsidised medicines, or you're going to have to pay more for your prescriptions, or some of the health budget's going to go from other things into paying for medicines that go into the pockets of the big drug companies. And so who benefits and who loses? So that's a second part of the claim. A third part of the claim, which goes back to some of the early work that Moana did on smoke-free Aotearoa, you remember that? Yeah. And which has been led by the Maori Affairs Committee, both Tariana and Hone. And the Smoke-Free 2025 policies are in particular directed at the impact on Maori of the addictions to tobacco, and that's been another really important international campaign. The Malaysians put forward a proposal that would have protected all of the smoke-free policies from the agreement, carved it out completely. Only got support from 2 other countries, not ours. The real crux issue for the tobacco was, some of you may have followed, that the plain packaging, that the ugly packs with people's eyes hanging out and all sorts of other ugly things that they have in Australia, that they were planning to have here, was subject to a court case by Philip Morris, using the kind of powers that will be in the TPPA. Investors get special rights to protect their investments, which they say include their logos on their packets, because they're very valuable. Who wants to buy an ugly plain pack with someone's eye hanging out? And in Australia, Australia has been sued in secret offshore tribunals for these plain packaging laws, and Philip Morris is demanding over $1 billion in compensation for the plain packaging on the basis of the losses that it would suffer. And Australia, in defending that, has currently had to pay $50 million in legal costs, and it's not at the full hearing yet. Right? Now, we know that the government here has backed off introducing the plain packaging until those kind of complaints are over. But that was one of the key challenges before the Waitangi Tribunal and in the negotiations. How are we going to stop that kind of policy being challenged under the TPPA by the likes of Philip Morris? And again, this is a partial victory of the challengers. There is a special tobacco exception that we are told that has been introduced in relation to the rights of the investors to sue on tobacco. But I can tell you, without going into the details on it, that it is not a full protection. And so again, we've had a partial victory, but not enough to know that we're out of the woods on being able to introduce the Smoke-Free 2025 policies. But the most critical of the 4 of the bases for the claim is the investment chapter. Now, we know that foreign investment is a big issue. Not only the responsibilities of foreign investors that they don't take seriously, whether we look around the mining and the arena, or in a range of the aged care industries with the big players there and so on. There are a whole lot of questions about how we can more effectively restrict foreign investors. Can we put more rules on them? What we know from the investment chapter is that the right to vet foreign investments from these countries, especially the US and Japan, Canada, the threshold is now going to be higher. So our ability to vet the foreign investment is going to be only for those who have higher levels of investment than at present. We also know that there will be some additional rules that those foreign investors can use if we try to tighten up the rules around them at present. Now, if we think about mining, we know that there is big controversy around mining, and we know that there's minimal regulation around mining. The foreign investors get special rules under the TPPA that say if we tighten up our domestic laws and policies in ways that seriously affect their value or their profits, then they can sue the government. That means all of the areas where we have very little regulation, they can sue. Implementing Treaty of Waitangi settlements that don't involve discrimination in favour of Maori, but for example mean that they're, and Ricky Gage is one of the claimants here, whānau Apanui's concerns about the offshore mining. You get stricter regulation around that, which they say is crucial to their role as kaitiaki. That is the kind of thing that a mining company is going to say, that's a changing of the rules on us in ways that undermine the value of our investment. We expected a stable environment when we invested, and you're changing the rules in ways that aren't good for us. We're going to sue you. And we're not going to sue you in your domestic courts. We're going to sue you in offshore tribunals. And not proper offshore courts, but offshore tribunals that are set up just for that case. The judges are 3 selected arbitrators, most of whom are also investment lawyers. So they act for investors, then they go and be judges, and then they go back and act for investors. There are no effective conflict of interest rules. So in some cases, we have people whose firms act for the same companies or on similar kinds of issues, and they don't have to disqualify themselves. We think they might have put in some new rules on that, but we don't think that they're very rigorous. There is no system of law like we have of if you have one case, then there is previous case law that's used to decide it. They make up their own. And often they get very adventurous. And even if there are rules in the treaty that are supposed to limit what they do, they say, well, nah, we think this. And the problem is that there's no appeal. So you've got no comeback when they do that. They can make massive awards of damages. I said with Philip Morris, they're looking at $1 billion. They can give compound interest from the date that the government did the thing. And so sometimes the interest is as much as the damages. And part of the effect of that is not just what happens in the cases, but it's what we call the chilling effect. We're going to threaten to bring a case. Yeah? If you don't back off, we're going to threaten to bring a case. Yeah? And we've already seen that work here with the tobacco. Yeah? And so you just imagine every time you've got a take that you are raising that a foreign investor is involved with, and they say, meh, especially if it's a US investor, who bring the most of these cases, or a Japanese investor, or a Canadian investor, or a Singapore investor, or we're about to start one of these negotiations with the EU, so any of the investors from the EU, and the government will say, $50 million Australia's paid so far and they haven't even got to the hearing? We're not going to spend that kind of money. And there was quite a significant recent case, and I could give you lots of examples of really bad cases, but I think this one is quite an important recent one. In Canada, which already has these kind of arrangements with the US, there was a local environment body which was looking at a resource consent for setting up a quarry and then an outlet into the harbour so that they could ship the stuff off. And a whole pile of people from the local community came along and said, we don't want this in our community. And the environment body said, okay, we understand, we're going to deny the consent. That's not an unfamiliar kind of issue for us. Instead of appealing that through the Canadian legal process, the company, Bilcon, a US company, took an investment dispute against Canada. Not the local body that made the decision, but the Canadian government. Local body didn't have any role in it. Bilcon, the mining company, the quarrying company, won on the basis that this had adversely affected their investment given their expectations of how they would be treated. We don't know yet what the damages will be, but we think it'll be about $400 million. The Canadian government will claim that back from the local authority. And the dissenting arbitrator in this case, because it went 2-1, said this is going to have a chilling effect on every environmental body's decisions when they're faced with similar kind of situations in the future. It's going to effectively mean that they are not going to be prepared to listen to the local communities and make those decisions. Now, these are real cases. There's another one about fracking. There's a moratorium on fracking in Quebec. That's being challenged. The Canadian courts denied a big pharmaceutical company a patent on a medicine. That's being challenged. So it spreads across a whole pile of areas. And we have very few of these agreements to date, and not with the countries whose companies bring the cases. So we are at really serious risk here. And we will be told, oh, we've got lots of protections in there. Well, we haven't got lots of protections. You'll be told that the Treaty of Waitangi exception will protect that. Well, I'm sorry, if I see 3 of those investment lawyers making a decision about what the Treaty of Waitangi exception means, I am not going to have any confidence whatsoever in what they come up with. Even if it applies, and it only applies to some kinds of investment disputes. And so it's that investment issue which is really big internationally. There's a huge backlash against this internationally. Yet our government has signed up to one that will be very hard for us to get out of. Well, it hasn't signed up to it yet. It's promising to sign up to it. And we have to stop them locking the door on our ability to make those decisions in the future. Other areas in investment including the Treaty of Waitangi assessment in foreign investment applications. That will go. So a whole lot of the demands that have been made in the past will be really difficult. So I hope that's given you a bit of a sense about, yes, it's not as bad as it was, but it is still a real concern. And it's once they've signed us up to it and it becomes binding on us, in practice, no governments have withdrawn from these agreements. So the final thing I want to say is you will be told that, yes, but there are good things in this. And FOMA has been out there putting its name to what's effectively the government's press release, saying this will be great for Maori exporters. Well, actually, there is virtually nothing in this for most of the exporters, and certainly not in the dairy area where they said that they were going to get the big gains. There may be some lower tariffs in the horticulture area, there may be some lower tariffs in the fisheries area, but I was actually talking to Amakura kawharu about this morning, and what it actually means for the economic development model. Because if you look at the initiatives that are happening, not just with Ngāti Whātua, but many other iwi, there are relationships being built internationally now that aren't built around these kind of agreements, that have big prices and that rely for the economic benefits on some removal of tariffs. It's about building relationships. It's about developing trust and effective kinds of commercial ventures that have the right tikanga and the right ethical base to them. And that if there is an economic model for the future that is to be a Maori-driven economic development agenda, it's not in these agreements. Okay? Now, we have to see the text. We hope that the text will come out early next month, and there will be about 90 days where we will be doing technical analysis and then trying to get it into a form that people can make some sense of. There will be a day of action involving protests in, currently we have about 8 parts of the country, but especially here and in Wellington. And that will be on Saturday the 14th of November. And we would love to see as many people there as possible, because the government believes now that the spin, we haven't had the text, they've had the text, they've been out there spinning like crazy what the gains are, and they think that they have bought people off. And it's incredibly important to get the message across to them that people don't actually believe the trust me stuff and want to have a say in our future. And then there needs to be pressure on the Māori MPs. There needs to be pressure on the Labour Party. There needs to be pressure on the local councils. And Ngāti Whātua has a particular role in the Tāmaki area. There's been quite a lot of debates at local councils around the country. We will be back in the Waitangi Tribunal. It'd be great to have some other claimants join. I've lost track of the claimants.
Well, it started off with 6, but I think it went up to 9 or 11.
Oh, no, I think we've got about over 20 now.
Oh,
and
the High Court case too, Jane.
Oh, yeah, okay. We lawyers have also been off trying to smash the secrecy. In January this year, the European Ombudsman said in relation to what Moana was talking about, this other mega deal between the US and the EU. They've all got these weird acronyms. This one's called TTIP. And she said TTIP is going to have such huge consequences for the citizens of Europe that it can't be negotiated in secret. You have to release the documents, you have to release the text, you have to tell people what's going on. And so I then put in an application to the Trade Minister for exactly the categories that she said should be released, and applied under the Official Information Act. She said, the Minister said no. We then had to go to the Ombudsman because we can't go to court until she's dealt with it, and she took nearly 5 months to deal with it, which was another story. But we got into court and the court expedited it, and we had a hearing about 4 weeks ago in the High Court in Wellington, and it emerged that the Minister had said no to releasing anything without looking at a single document. He just said, I know everything that's in there. I know none of it can be released. It's super sensitive. And if it's not super sensitive, it's so anodyne that no one's going to want it anyway, which is not a ground under the Act, but never mind. The judge was really good. He came out with a judgment within 10 days. So anyone who's had anything to do with court proceedings, getting a judgment out in that time is found for us. But the problem is that the Minister now has to go back and make the decision again based on proper grounds. We don't know if they're going to appeal yet, but it is a moral victory in saying that this kind of secret democracy is not actually acceptable, and we will appeal it if we have to, but we think they might want it just quietly to go away. But it's important that we did that challenge, and it's important equally that we have lots of voices out on the 14th of November and afterwards, because as Moana said, there are at least 2 more of these negotiations that are happening now. And if we don't stop the secrecy, and if we don't stop the doing of the deals now, we will have more of them and more of them, and our ability to decide our future and the ability to honour te tiriti, to have anything based on tino rangatiratanga in this country will be signed away without us having any role to play in it whatsoever. So that's why it's important.
I think so.
Yeah. Kia ora.
Jane, can I just ask a question on our behalf, just to clarify? America is really important in this because the presidential elections are coming up, so that gives us some kind of a time frame.
Yeah.
Can you just explain why we need to put the pressure on?
Yeah. At every stage of the process, if you think about it like going through a submarine and the water's coming behind you and you lock the door and then... Is that analogy going to work?
Yeah.
Yeah.
So you drown at the end.
Yeah. Basically, it gets harder and harder to stop each stage along the process. Right? And they're now one stage into what's about a 5-stage process. Right? They've done the political trade-offs to do the deal. But, as Moana said, the US is the big player in this. And the US politics around this is really toxic. Right? Obama had to get an approval from the Congress to negotiate the deal in a particular way, and I won't go into the details of it. But to get the support of Congress, he had to rely on Republicans. There were almost none of his own party who would vote for him. Yeah? Now, under the law that was passed, he has to give 90 days notice to the Congress before he can even sign the deal, and he has to release the text 30 days into that 90 days. So that's how we know that we will get to see the text 2 months before it can be signed. Right? Then once they've signed it, it's not binding on each of the countries. Right? It's a signal that we intend to be bound by it, but it doesn't bind us. So each country has its own processes. We have a really weak process. The cabinet decides if it's going to bind the country. Right? The Parliament has a select committee hearing and you can make submissions, and we will make submissions, but the select committee has no power. It will only even have a symbolic vote on it in Parliament if they can rely on Labour to vote with it. They don't have to have a vote on the treaty itself. They only have to have a vote on any minor pieces of legislation that have to be changed to make us comply. And that's going to be a couple as copyright law and a minor tariff law. No? So basically the cabinet can do this without our parliamentary process having any effective role. But in the US, the Congress has power. And they have an election next year. And a majority of the presidential candidates from both the Democrats and the Republicans at this time have said they don't agree with the TPPA. And it will be a major election issue because people over there are not convinced that these agreements are good for them. They've had one between the US, Canada and Mexico that didn't do any of them any good except for the big companies. And it's the big companies who have been at the table negotiating this. They have a process in the US of what they call cleared advisors. There's about 600 of them, and all but about 15 of them are corporates. They get to see the text. No one else gets to see the text. They get to see the text. They get to suggest what should be in the text, what they do like, what they don't like. And so these are seen as corporate-driven agreements. It was a big fight before even members of the Congress were allowed to see any of the text themselves. Our MPs here still aren't. And so inside the Congress, the Democrats see this as a deal that is bad for working families in the US. And they will be campaigning. A number of the major funders for the Democrat Party have said they will not fund any presidential candidate or any candidate for congressional seats that supports the TPPA. And so there's a question of when it gets presented to the Congress and what the vote there will be. Now, the earliest we've told it will be presented to the Congress for a vote will be in August next year, which is when they call the lame duck period, where they can't do anything except vote for toxic deals, and then they're going out of office, so they don't need to worry. But it could be 2 years. They could hold it up for 2 more years there, which gives us 2 more years to fight against it here. And then there will be a process at the end of it that when the US has agreed to it, they have another dirty little trick, which is that the US won't agree to the TPPA coming into force with New Zealand until New Zealand has changed our laws and policies to what the US says the agreement requires us to do, not what we think it requires us to do. Which means the US, and there's a website called tppnocertification.org where we've documented this, the US has used this in the past to say, well, you think that this piece on medicines means this. Well, we don't. We think it means that, and unless you change your laws to what we think, it's not coming into force. It's done it with environment laws. It's done it with, in Peru, forestry issues that created such a furor, and there was on indigenous lands, and people died in the protests around the lands. And that's right at the end. It's basically the US rewriting the deal to what the US wants the deal to say. Sometimes not even what's in the text. It says, oh, you said this in the room. Well, sometimes you said no, but we still won't bring it into force until you say yes. And this is one of the reasons why the Official Information Act stuff was so important, because we need to know if that's going on. Because if that kind of backroom trading is taking place and we don't know about it, the US is effectively writing our laws. That was a much longer answer than you anticipated, my dear.